Welcome to The Free Will Show, a podcast that provides a beginner-friendly introduction to free will while also exploring cutting-edge developments on the topic. I'm Taylor Sear.
And I'm Matt Flummer. In this episode, we talk with Stephen Morse about the nature of addiction and about the moral and criminal responsibility of people who suffer from addiction.
Thanks for listening. I'm happy to introduce Stephen Morse, Ferdinand Wakeman Hubble Professor of Law, Professor of Psychology and Law in Psychiatry, and Associate Director of the Center for Neuroscience and Society at the University of Pennsylvania Carey Law School. Stephen works on issues of individual responsibility and agency, and he's the author or editor of many articles and books, too many to list here. But one that might be of special interest to our listeners is a volume that Stephen co-edited with one of our former guests, Adina Roskies. The volume is called A Primer on Criminal Law and Neuroscience, a contribution of the Law and Neuroscience Project, which was supported by the MacArthur Foundation. And then the book was published by Oxford University Press in 2013. One of the topics that Stephen has returned to again and again over the course of his career is that of addiction and the criminal law. And that's what we've asked him to talk to us about today. So welcome to the show, Stephen. Could you start by telling us a bit about yourself, your work, how you came to be interested in working on issues related to responsibility in the law?
Sure. First, I would say, though, about the book you just plugged, and thank you for that,
Sure.
is although it was written a decade ago, I don't think any author in it would probably change one word yet.
Oh,
I mean,
wow.
despite the advances in neuroscience since 2013, and there have been many, and some of which are quite astonishing, actually, none yet, in my view, and I think the other authors' views, would have changed the law at all. But we'll come back to that.
Okay. Yeah.
So I started getting interested in issues of individual responsibility in my first year of law school when I took criminal law. You may recall that that was, by the way, the fall of 1966. I'm a dinosaur. And you may also recall that West Side Story was first performed in 1957. And there was this famous number in it, Officer Krupke, in which a group of juvenile delinquents are confronting a juvenile parole officer or something of the sort, Officer Krupke, and one of them is trying to explain why he's a delinquent. And, the excuses, his parents, the society, anything but him. And I remember thinking, and of course, in 1957, it was a send-up of that view. But that view became very, very prevalent in the 60s. And by the time I was in law school, there was already what I call creeping Krupkeism, which I consider a pernicious view that people are not responsible for their behavior in most circumstances, as opposed to not responsible in only a small minority of circumstances. And so I got very, very interested in human behavior. As I'm fond of saying in law school, I was interested in crime, crazies, and kids. And although the money package was very alluring financially and interesting intellectually, it just was not where I wanted to put my career. And I remained interested in those issues of personal responsibility and decided that if I was really going to be, because in the 60s, we all wanted to change the world. If I was going to help change the world, I needed to understand more about human behavior. Because the law is a very blunt instrument. It doesn't do much to help people prevent themselves getting into trouble. And when they get in trouble, as opposed to really helping them out, it tends to beat them over the head. So what I wanted to see was, if I learned more about human behavior, could the law be a better instrument of helping people flourish to begin with, and when they didn't, of helping them flourish again, or even for the first time? So I decided I needed behavioral science training. And that took me to get a PhD in psychology. And the branch I did was personality and developmental studies in a very empirically rigorous program. My program trained you to be a bench scientist. But I was interested also in clinical work and got clinical training at the same time. And then the question was I going to be a law professor or was I going to be a psychology professor? And it seemed to me that I'd be better off, given my aspirations of doing normative sorts of things, of being a law professor who consumes psychology, as opposed to a psychologist who maybe gets one study after 3 years of work, and then it's not going to change much anyhow.
Yeah.
So I became a law professor. And what I quickly learned, interestingly enough, was that philosophy actually was more interesting and important for figuring out the kinds of problems I was working on than the behavioral science. The behavioral science was, of course, relevant and important, but not as much as philosophy. And that led me into the free will thicket in a big way. Of course, we had discussed these issues in college. I still remember the bull sessions about determinism and freedom and all that. But now I had to do it in a semi-professional way. I mean, you, Taylor, I don't know what your background is, Matt, but you, Taylor, I know are a professional philosopher. I'm not, but I'm, at least in the sub areas in which I work, I'm a pretty good fellow traveler. Right. And once you're interested in individual responsibility from a philosophical as well as behavioral point of view, addiction is a natural focus of your attention, because it is a behavior or a set of behaviors that really do call into question fundamental assumptions of personal responsibility. So that's how I got interested in addiction. And I started working on it in the late 70s. And I've been working on it ever since.
Yeah, very cool.
Cool story.
Well, it's common in debates about free will for philosophers to talk as addicts as acting without free will, and in some cases as though addicts suffer from literally irresistible desires that compel them to give into their addictions. But some philosophers, for instance, Neil Levy and Hannah Pickard, point out that while addiction is clearly terrible, real-life addicts may not resemble the typical characterization that we see in philosophy. Can you tell us a bit more about the nature of addiction as you understand it?
Yeah. Well, first of all, you have to consider what addiction is. And the working definition, I mean, if you look in DSM-5 TR, text revision from a couple of years ago, or if you look in the International Classification of Diseases, now in, I think it's the 11th version, basically you'll see criteria for substance use disorder. And in DSM, it's broken down not as a generic category, but alcohol use disorder, cocaine use disorder, opioid use disorder, et cetera. But the general working definition most addiction researchers use is the persistent seeking and using of substances. Typically, and now there's disagreement, that everyone agrees on. Right. If you're not persistently seeking and using substances, you're not an addict. For many people, it's got to have adverse consequences. Social, interpersonal, financial, legal.
Is the adverse consequences part of the DSM definition?
No, it is not. Okay. Although it's a typical feature, especially for those who are using illegal substances. And then there are some people who want to say compulsively, but that's controversial still. So it's basically persistent seeking and using of substances. Well, notice what seeking and using are. They are actions that can be explained by the same kind of practical reasons that explain why the three of us are having a conversation today. Right. I desire to do drugs. I believe that if I take the drug, I will feel better, and therefore I form the intention to take the drug. And so since they are human actions, they can be morally judged. Something I think that many, many addiction researchers would agree with. In fact, I once had a back and forth in a journal with Steve Hyman, who's a very well-known neuroscientist who works on addiction. He's a psychiatrist and neuroscientist, and he had to concede that point, and he happily did so. So, okay, what is addiction besides this definitionally the persistent seeking and using of substances? Why did people do it? Well, when I teach this to my students, my law students, they look at me dumbfounded, what a ridiculous question. And I say, finally, someone says, well, I guess because they like it. I say, you bet. People, unless they're really kinky, don't take castor oil for pleasure. I mean, they take drugs for pleasure, right? And I know that in many quarters, people want to say, when doing this for pleasure starts to become a problem for the individual. Then they get into a situation where they don't like it anymore, but they still want it, where liking and wanting come apart. A philosopher named Holton is most famous for, I think, first making that point. But notice they still want it. And now they don't want it because it's going to produce pleasure necessarily, but because it's going to avoid pain. They still have a good reason for doing it. At that point, we have to ask if it's really ever literally compelled. And the answer to that has got to be no. If I hold the gun to the head of the most debased addict in the world, somebody with the worst addiction ever on record, and I say, you touch that substance, I'm going to blow your brains out. Unless they want to die, which is an independent problem, they're not going to touch it. And, when I say things like that, sometimes people push back and say, well, what about when the urge to urinate just becomes overwhelming? You can hold a gun to somebody's head, and finally, if they're not allowed to void, they're going to void involuntarily. And I'll say that's because the sphincter muscle gives out, and that's mechanically explained, unlike the explanation for why the addict persists in seeking and using. All right, so this is a long introduction to say, for me, but you really need to have that as an introduction to get to the nub of the matter. There are basically three camps, essentially. One camp is addiction is a pure moral failure, the highly moralized view. There are still people who take that position. I don't. On the other extreme, there are the people who say it's, persistent seeking and using is the symptom of a disease, and therefore these people are not responsible. Mm-hmm. The problem, of course, is that it's question begging. Given that it's a human action, unlike most signs and symptoms, it can be morally evaluated, which most, a metastatic process or spiking a fever as a result of an infection are purely mechanical processes, which is not to say that some diseases can't be affected by lifestyle choices and things like that. We all understand that diabetics probably ought to lose weight, et cetera. Or if you have serious heart disease, don't smoke, lose weight, get some more exercise, stuff like that. But the basic underlying processes you can't stop by deciding you have a good reason to stop. All right. So I'm in the middle camp. And the middle camp is, and this is where I think Neil Levy and Jeanette MacDonald and Hannah Picard are, is that it's a really bad habit. A really, really bad habit. And I don't know if either of you has any really bad habit that's not good for you, but they can be damnably hard to break. Mm-hmm. And therefore, since it is damnably hard to break, that does suggest that maybe these are people whose responsibility when they do give in should at least be mitigated, if not altogether excused. And that gives it an argument. And there is now, I think, a very lively argument among the middle campers, who I think are the most sensible people. And even NIDA, the National Institute of Drug Abuse, which is responsible for 100% essentially of addiction research funding in the United States, such that when a case involving addiction went to the Massachusetts Supreme Judicial Court that got national attention, I was one of the co-authors of a brief on behalf of the Commonwealth that said there ought not to be, I'm now paraphrasing, an excuse for addiction. And essentially, we could not get almost any addiction researcher to sign the friend of the court brief that I co-authored. And they would say, we totally agree with you, but we'll never get another nickel in research funding if we sign on, which was fascinating, absolutely fascinating. But even NIDA researchers, or many of them, or administrators and spokespeople will admit even though they clearly adopt the disease model, their mantra is it's a brain disease, addiction is a brain disease, and it matters. And my response is, no, addiction is not a brain disease, and it does matter that it's not. So And we can get into questions of responsibility quite soon, but that's my take. It's a really bad habit. And ultimately, when the person becomes habituated and has the bad habit, at that point, it's no longer their fault that they have this set of very strong desires
Right.
to do something they know is not good for them.
Yeah.
Mm-hmm. Yeah. That's really helpful, and thanks for laying out all the different positions.
Yeah.
As we turn now to thinking about criminal law in particular, maybe before we talk about how addicts are held responsible in the criminal law, you've written some about what you take to be the responsibility criteria of the criminal law.
Sure.
Could you explain what you take those criteria to be?
Yeah. The criminal law is, or each crime is defined by what lawyers call the elements of the crime. These are the criteria for culpability that the state must prove beyond a reasonable doubt. And they are, one could complicate the picture, but this is good enough for government work. Those criteria are typically a voluntary act, a so-called voluntary act, which can be defined as an action performed as a result of an intention in a reasonably integrated state of consciousness. So sleepwalking would not count. The three of us presumably would count in terms of our speech acts today. Okay. Then, and the next element is the most important typically for culpability, a mental state that makes what you did the wrong thing to do, a culpable action. So let's take a classic definition of murder. You have to engage in intentional killing conduct. That's the act requirement. And by the way, most murder statutes don't specify specifically how it should be done. We don't have a special statute for shootings versus knifings versus nunchakuings. Yeah, whatever method you use is whatever method you use. And then for murder, it typically has to be done on purpose, with intent. Mm-hmm. If you kill with a lesser mental state, I intentionally drive and run somebody down. If the way I am driving is so life endangering and I'm consciously aware of the risk that it is, I don't intend to kill anybody, but I am consciously endangering human life, then that's typically a lesser form of homicide. And if I'm not aware of the risk somehow, but should be, then it's an even lesser form. Those are called recklessness and negligence, respectively. Right. Okay, let's assume the prosecution is able to prove, let's just use murder. Prosecution is able to prove I'm done something intentionally. I intended to kill a human being. I'm prima facie liable. Those elements the prosecution must prove beyond the reasonable doubt. But that doesn't end the culpability inquiry or the responsibility inquiry. You then have to ask, was there any justification or an excuse? So a classic justification is self-defense. In cases of justification generically, you're doing what would otherwise be wrongful, but it's right under the circumstances. Better that a wrongful life-threatener, aggressor, should be killed than I, the innocent agent, should be. So if I make a reasonable judgment about my danger, then I'm entitled to defend myself, intentionally to harm somebody, which would otherwise be wrongful, even to kill them in cases of life-threatening aggression. What we're talking about, obviously, we're talking about addiction, is excuses. Addicts, they know what they're doing. They intentionally use the drugs. We've seen that. It's a human action. But might they be excused? In case of excuse, the agent has done the wrong thing, but is, for some reason, not responsible. And generically, there are basically three excusing conditions. One is lack of rational capacity. More controversial is lack of control capacity. And the third is hard choice, where through no fault of your own, you're placed in a do it or else situation. So I hold a gun to Matt's head. Matt's an innocent agent. And I say to him, Matt, you don't appear to be in the same room, but okay. I say to Matt, kill Taylor or I'll kill you. He intentionally kills you to save his own sorry behind. So in that case, did he intentionally kill you? Sure he did. Did he know what he was doing? Yeah. Is he morally impaired? No. But I placed him in a hard choice situation, do it or else, through no fault of his own. I'm just the total malefactor. So at least in many jurisdictions, he'd get an excuse, and it's called duress. Addiction, obviously, falls in the middle category for most people. They think they somehow lack control capacity. You know, when addicts say things like, I can't help myself, especially if I'm stressed out or I'm in pain psychologically or physically or whatever. So that's the criterion that's going to be most applicable. It's not going to be the prima facie case.
That makes sense.
Yeah. Interesting. All right, let's turn to, we've talked about responsibility. Now let's talk about criminal law. So given your understanding of the nature of addiction, do addicts typically meet the responsibility criteria for criminal law?
In my view, they do. And I can explain this in a number of ways. First, when they actually commit the crime they do, they may actually not be in a responsible state at that moment, the moment of peak desire when they finally give in. Now, I've come up with two proto-theories for why that might be true. The first is the desire is so strong they can't access the good reasons not to. The other is a bit like an analogy to duress. The fear of dysphoria by not finally using the drug, whether it's physical withdrawal for some drugs or the psychological pain of not having it for other drugs, or both in some cases, is so great that we really can't expect them not to yield. So that's what I call the internal gun to the head model. And I don't know which is right, but let's assume you think one or both are plausible. There's still a problem. At the moment of taking the drug or doing whatever else they do as a result of their addiction, they may not be responsible. But when they're quiescent, and addicts are not at every moment in a state of peak desire where they can't access good reason or fear the consequences if they don't take the drug, in those quiescent moments, they are able to access good reasons, including the availability of treatment modalities, etc. And therefore, at that moment, knowing that they are at risk of behaving in ways they've been habitually behaving for a long time, or in some cases not so long, they have a duty to take whatever steps are necessary so that they don't get themselves in trouble again. So they're diachronously responsible. And so I think the law is not wrong to hold them responsible. There's an analogy. There's a famous case that raised it. Fellow had epilepsy. This was a while ago, before we had as good control over seizures as we do now. And we don't know how controllable his seizures were. But in any case, he gets behind the wheel of his Buick one day, and while he's out driving, he has a seizure, blacks out. So there's no voluntary act while he's blacked out. And he runs his Buick up on the sidewalk and mows down 4 pedestrians, kills them. Well, at the moment he ran them down, he was not a responsible agent. But when he got behind the wheel of the car, when there was nothing wrong with him at that moment in terms of his responsibility criteria, either knowing or should have known that he could black out, and the law held him responsible for a form of risk creation homicide on the grounds that he should have known he could be a real danger, substantial danger of death. So he was diachronously responsible. Or the other thing you could say is his really culpable act that causes a death was driving, per se.
Right.
Either way. So again, let's assume you are a child molester. You better not walk home by a kid's playground. Take an alternative route home. In the same way, if you're a alcohol abuser, don't walk home on the route that passes McGinty's bar. And of course, if you're a child abuser and a alcoholic, you better find a third route altogether.
Yeah.
Right. Yeah, that makes sense. We have a couple other questions too, especially that have to do with kind of more recent work on addiction. So, are there any common misconceptions of addiction, or of how addiction may affect how someone's held criminally responsible?
Yeah, I mean, I think the common misconception is to think of addiction related behaviors as just like mechanical signs and symptoms of other diseases.
Right.
And once you think that way and you've totally medicalized the problem, then it's much too easy to slip into the notion that these people, you're not responsible for your fever, you're not responsible for your metastasis. Why should you be responsible for your addiction related behaviors? And that's just an out and out mistake. And in fact, in the first Supreme Court case to deal with this, back in 1962, called Robinson against California, Walter Robinson was a really, really debased alcoholic. And California had an ordinance, a statute rather, that made it a crime to be an addict, not to do addiction related things like using or
Right.
possessing, but just being an addict. And they knew it because he had needle marks on his arm. That's how the cops discovered him. He was a vagrant, and I guess the cops were rousting him or something of the sort. And he challenged the constitutionality of that statute, went all the way to the Supreme Court, and there were 7 opinions in the case.
Wow.
7. I mean, no one could come up with the good theory, but in a 7-2 decision, the court held that, in fact, you can't criminalize just being an addict. And essentially, there were 3 theories running around in the case. One, you can't criminalize for disease. Since addiction always depends somewhat on behavior, the behavior may be involuntary for addicts. And the third was it's just a status, like having brown hair or wearing glasses or something. It's not an action at all. And it wasn't clear what the theory was.
Right.
And people use the disease theory in a case from 1968 that involved a man suffering also from alcoholism, Leroy Powell, and Powell against Texas. Justice Marshall wrote the plurality opinion and said those who are arguing that it's a disease are asking us to do too much legal change based on too little knowledge, and held that if Texas wanted to criminalize being drunk in public, even for addicts, where there was evidence that being drunk in public, at least in Powell's case, was a compulsion symptomatic of his disease, Texas could use the criminal law if it wanted to. And a philosopher, Herbert Fingerat, who may be familiar to you, longtime member of the faculty at UCal Santa Barbara, and his daughter, a lawyer, Anne Fingerat Haas, showed definitively back in the 70s that disease does no work whatsoever in explaining why you might want to excuse addicts. It's going to have to be either involuntary actions or status. And in Powell against Texas, they made clear Robinson should be interpreted as a status case. And that still stands. That absolutely still stands.
Yeah. Do you think that current legal doctrine and practice concerning addiction is defensible? And are there any places where you think reform might be beneficial?
Absolutely. I think the answer to both cases is yes. I think it's plausible on the argument I made before for the responsibility of addicts. And by the way, nowhere in the United States, not in any state and not in the federal system, is addiction conceivably the basis for an insanity defense, for example. Nor does it have an independent excuse status. There's one sort of exception to that. If you are involuntarily intoxicated somehow, then you, as long as you meet what would be otherwise the criteria for legal insanity, you don't know what you're doing, etc., then you would get an excuse of involuntary intoxication. But almost never happens, and it applies to non-addicts as well as addicts. If persistent use of substances makes you permanently crazy, then you can use the insanity defense. But that's not most addicts. So most addicts, I think, plausibly can be held responsible. Having said that, I think, first of all, were much too harsh on the crime of personal possession for personal use only. In other words, possession not with the intent to deal. Now, I'm very, very much provisionally in favor of decriminalizing substances more generally. So this probably affects my views. But I think even if I weren't in favor of more broad decriminalization, I would still think that possession for personal use should not be a crime, period. Possession with intent to deal, well, if you think that drug infractions are serious crimes, then I think there's no reason not to punish. How about if someone commits really serious crimes? And I know I'm begging the question about levels of seriousness, but I'm sorry, I think things like aggravated assault and homicide are more serious than possession with intent to deal. In those cases, since the addict who engages in those behaviors to support his addiction, to steal, to get money, whatever, I think in those cases, the addict has such good reasons not to do it because of the awfulness of what he's about to do or she's about to do to another human being that I would not give them any mitigation or excuse whatsoever. In some cases of addicts who became very, very sort of broken down as a result of their addiction and they commit crimes, I would be inclined to mitigate, but not entirely excuse.
Mm-hmm.
Yeah.
I should say, by the way, for my work on addiction, and you may not be aware of this, and this is another misconception people have. Once an addict, always an addict.
Mm-hmm.
It's incurable, quote unquote. The vast majority of addicts, and we have wonderful epidemiological evidence of this, and for the listeners who may find this rather incredible, I refer them to a book by Gene Heyman, Heyman, Addiction, A Disorder of Choice, Harvard University Press, 2009, who has done the epidemiology. And in light of criticisms he received, in 2013, he re-reviewed the evidence in light of the criticisms, came out exactly the same way. The vast majority of addicts quit on their own without professional assistance. In fact, addicts in treatment are more likely to relapse than addicts not in treatment.
Really?
Yes, but there's an artifact for reason why. Addicts in treatment tend to be dually diagnosed, and meaning they have comorbidity. They have another disorder as well as their bad habit of addiction. And therefore, the kind of treatment they're getting for addiction might not do much for the co-occurring disorder, unless the co-occurring disorder is a product of the addiction itself, which it very well may not be.
Right.
So why do most addicts quit? We don't have, and by the way, I shouldn't say, they quit once and for all the first time they try. Most addicts, believe it or not, start trying not long after they become addicted. And they typically, in their 20s and 30s, have a number of failed attempts. They start using again. By their early 40s, the vast majority have quit permanently, no longer meet the criteria for a substance use disorder. And we don't have good data about why they quit, but there's lots of anecdotal evidence out there. And it all points to the same thing. When people finally have a good enough reason to quit, they do. So if you interview these folks, they say things like, my family was ashamed of me. My kids were ashamed of me. I was impoverishing my family. I didn't want to spend the rest of my life in prison. And they go on and on like that. I have a wonderful anecdote of a friend who was another law professor who was morbidly obese, but he was a great athlete. One of these guys who's really overweight, but is extremely coordinated and graceful. And he loved to ski. And his orthopedic surgeon said to him, look, if you keep this up, you're going to end up in a wheelchair and you'll never ski again. Keep up your weight. You've got to lose weight. And he never did. And if you watch this guy at a buffet kind of meal, he just shoveled food in it was almost like looking at a mechanical process. And then he went away on sabbatical for 6 months, and I hadn't seen him. And I saw him, and he had lost all this weight. And I said to him, so-and-so, why did you lose all this weight? Did you finally listen to your orthopedist? He said, oh, no. But while I was away, I had a test that showed I was pre-diabetic. So I just stopped eating. And it was interesting. You would have thought being permanently crippled would have been a better reason. But no, for him, the possibility of diabetes was the good enough reason. And he just stopped.
Yeah.
And he was a food addict if ever there was one.
Mm-hmm.
Interesting.
Yeah, I've heard stories like that too. I talked to somebody who was an alcoholic and started to have thoughts of suicide. And he said as soon as he had those thoughts, he didn't touch it ever again because that was a good enough reason to quit.
Yeah. Yeah, that's a perfect example. I'm not suggesting, by the way, that people who quit have no help. They go to AA. Mm-hmm. They talk to their clergymen. They have friends and family that support them. There's a very nice study out of Harvard that showed all the various non-professional ways that people get help to quit. But ultimately, they quit. They're human beings. And by an intentional action, or in this case, it's an omission, they stop.
Yeah.
Now, I'm not saying that we shouldn't help people who want to stop with medically assisted treatment, as we call it, MAT, or other sorts of things. I'd offer addicts anything I could to help them quit.
Mm-hmm.
I mean, it's not that it's your own, you made your own bed, lie in it. It's a really bad habit, and if I can help you break it, I will. Yeah. And I used to treat addicts when I was in clinical practice of psychology, and I found their cases very moving.
Right.
Yeah.
Well, this has been fascinating. Thank you again, Stephen, for joining us.
Thank you.
Yeah, you're welcome. Where can listeners go to follow your work?
Well, the easiest way is to just go to my website at the University of Pennsylvania Law School. So just basically go to law.upenn.edu and go to faculty and go to me. And you'll find right there, you list all my publications.
Nice. Yeah.
And if they want to know what I look like, they'll find a very nice picture.
Yeah. Well, thanks again, Stephen.
My pleasure. Thank you for having me. And good luck with your podcasts.
Thank you.
Thank you. Our next episode will be the last one of this season, and we'll talk about forgiveness in the law with Simone Gubler, Assistant Professor of Philosophy at the University of North Carolina, Chapel Hill.